guests, both in person and online, thank you very much for joining us today for this panel on Southeast Asia and its re-engagement with the sources of public international law. Coming live to you from The Hague, on my right-hand side, I have Professor Romed Cassis, who will be presenting a little bit later on, and we are also waiting for Isroni Mohammad Mirai Mirza, who is currently stuck on a train, because as you know today we have the general strike on trains in the Netherlands, and as soon as he is with us, he is also going to make his presentation here in person. Online we are very happy to welcome from Geneva, Tikmpon Rodhongwan, who will be also making his presentation as according to the schedule. So seeing that currently we do not have connection with Ms. Melissa Loya, I think it's only fair that I give the floor to Professor Cassis for his presentation. Before I do that, I think it's only proper that I briefly introduce our speaker. So Professor Cassis will be talking about the re-engagement through domestic reinterpretation of sources. He is a tenured full-time faculty member of the University of the Philippines College of Law, teaching public international law and supervised legal research in the JD program and international environmental law and international humanitarian law in the LLM program. He was appointed Director of Studies for the summer of 2027 of the Hague Academy of International Law. Professor Cassis is the State Practice Rapporteur for the Asian Yearbook of International Law and Managing Editor of the Asia Pacific Journal of International Humanitarian Law. He wrote the Philippine volume of the Encyclopedia of Public International Law, among other books and articles. Professor Cassis, it's an honor to have you with us here today. Thank you very much for coming. The floor is yours.
There you go. All right. So, good morning to everyone. I'll try to work on 2 laptops this morning. The title of my presentation is Re-engagement through Domestic Reinterpretation of Sources. I'm grateful to Dr. Bagues and the organizing committee for inviting me to this conference. Now, this is the basic outline of my paper, and the introduction provides a brief overview of the paper. And it starts with explaining that this paper is about what I refer to as streams of influence. The first stream of influence is through the work of the International Law Commission, or the ILC. Specifically, I'm referring to the draft conclusions on the identification of customary international law, or which I call the DCICL, the draft conclusions on the identification and legal consequences of peremptory norms of general international law, which I call the DCIL-CPN, and the continuing work on the draft conclusions for the identification of general principles of law, which I call the DCGPL. The paper argues that these works create opportunities for Southeast Asian states to influence the future design of international law. Now, the second stream of influence is through domestic judicial decisions that dissect and process the rules on sources. Now, the paper argues that the Southeast Asian domestic courts can shape international law in this way. Now, after the introduction, part 2 briefly describes what we all know about the current state of international law, specifically that the past and present of international law is dominated by the West, and that there is a need for Asian influence. Part 3 discusses the streams of influence. Part 4 provides some recommendations in light of the streams of influence, and Part 5 offers brief concluding remarks. Okay. So, in the interest of time, let me jump immediately to Part 3, which is the streams of Southeast Asian influence. It seems like the slide it shows part of it. Okay. Anyway, so the draft conclusions. First, let's talk about the draft conclusions. The draft conclusions on custom were adopted in 2018, and it opens the door for Southeast Asian influence in at least 3 ways. First, on the requirement for general practice. As we all know, to form custom, practice must be general, which under the DCICL means that it must be sufficiently widespread, representative, and consistent. Thus, the collective practice of Southeast Asian states can contribute to this or can prevent the establishment of custom. Second, resolutions of international organizations. These resolutions provide evidence for the existence and content of customs. Now, Southeast Asia has a long-standing organization, the ASEAN, and most of the ASEAN members are also members of other international organizations, such as the UN and many others. By actively participating in drafting resolutions and even proposing them, Southeast Asian states can direct the development of customary international law. And thirdly, which I find interesting in the DCICL, is the recognition of particular customary international law. Now, particular, as you know, customary is supposed to be general, universal, but there are cases where the court and other courts have recognized regional customary norms. Now, in the DCICL, they could be regional or local. And the practice among Southeast Asia can create particular customary international law. In fact, custom may develop among a smaller number of states, not all 10 states of ASEAN, for example, because in the DCICL, particular customary international law may cover a smaller geographical area, such as a sub-region or even bind as few as 2 states. So even the practice of just 2 states in Southeast Asia may create custom. Now, the peremptory norms, or the DCICL-CPN, my own acronyms are messing me up. It's supposed to make things simpler. So in 2022, the ILC adopted it, and this opens the door to Southeast Asian influence in at least 2 ways. First, it provides that peremptory norms must reflect and protect fundamental values of the international community. This is one significant, I think, development in these draft conclusions. This means that for every peremptory norm, there must be at least one fundamental value being reflected or protected. And these fundamental values can be identified by national court decisions and scholarly writings. So these decisions and these writings open an avenue for courts and scholars in Southeast Asia to help develop peremptory norms by identifying Southeast Asian fundamental values. So they can do this by discussing these values in their writings and in their decisions. Note that the fundamental values, according to this draft conclusions, they belong to the international community, not just the states. So other actors beyond states can promote these fundamental values. So even non-state actors like NGOs, academics, and other institutions in Southeast Asia can establish these fundamental values. The second way is the requirement for acceptance and recognition. Because peremptory norms to exist must be accepted and recognized by a very large representative majority of states. So it's not even simple majority. The majority had to be very large. That's how it's explained by the ILC. So this requires that the acceptance and recognition be across regions, legal systems, and cultures. And because of this heightened requirement, this is a higher requirement compared to the requirements for custom, the role of Southeast Asian states is even more significant. In fact, it could be argued that no peremptory norm can be accepted and recognized without the support of Southeast Asian states. General principles of law. Now, this work is not yet finished. But in 2023, the ILC adopted 11 draft conclusions and its commentaries. And it also opens the door to Southeast Asian influence in at least 2 ways. Because to be considered a general principle of law, a rule must be recognized by the community of nations. And that phrase, community of nations, means that all nations must participate equally without any kind of distinction. This means that the recognition of, let's say, of any single Southeast Asian state would be equal to the recognition of any Western state. And the second way is through the so-called categories of general principles of law. Now, in the DCGPL, categories actually refer to the sources of general principles of law. GPLs are normally derived from national legal system, and that's the first category. Now, to determine this, there must be a wide and representative comparative analysis of national legal systems. This requires that different regions of the world must be represented in this comparative analysis. So, if you look at Southeast Asia as a region, it's already diverse in terms of legal traditions. You have states coming from the common law and civil law traditions, and even within those strands, they are represented in Southeast Asia itself. So, they can contribute to this comparative analysis. Second, one controversial aspect of the DCGPL is the recognition of general principles of law from the international legal system. And this requires analysis of existing rules in the international legal system, and this can be found in international instruments coming from international organizations. So similarly, ASEAN instruments, which have been there since 1967, can be an important source of general principles of law. Now let's move on to domestic judicial decisions. Now, judicial decisions play an important role in international law. Article 38, as you know, of the ICJ statute, include judicial decisions as a subsidiary means for the examination of the rules of law. But looking at the conclusions as well, for customary international law, peremptory norms, and general principles of law, the ILC draft conclusions all say that regard may be had to national court decisions. This was not explicitly stated in the ICJ statute, but in the conclusions, it is. Now, let's look at Philippine cases. Under Philippine law, only Supreme Court cases of the Philippines can set binding precedents. So all the decisions of the other courts don't matter. And only its cases, the Supreme Court cases, are actually publicly accessible in volumes. So in this part, we will take a look at decisions of the Philippine Supreme Court. So let's look at treaties. Now, interestingly, in the case of treaties, Philippine domestic interpretation comes not only in the form of judicial decisions. You also have a very important administrative issuance, and this is known as Executive Order Number 459, or EO 459, which actually not only defines certain things, it reinterprets some of the principles on the law on treaties. For example, and there are many, but one example is the definition of treaty. EO 459 defines treaties as a contract or understanding, regardless of nomenclature, entered into between the Philippines and another government. Noticeably, this is more liberal than the Vienna Convention on the Law of Treaties, which require that the treaty must be between states. Now, in our domestic reinterpretation, the Philippines may execute a treaty with governments. This term makes it possible to have treaties between the Philippines and entities that are not recognized or have controversial status as states. We also recognize the concept of executive agreements, which is strangely defined in EO 459 as similar to treaties, except that they do not require legislative concurrence. Treaties requiring legislative concurrence. So the thing is, though, executive agreements under Philippine law are just as binding as treaties. And the only requirements are that they are traceable to some authorization in law or in the Constitution and must not be inconsistent with law and other treaties. Apart from these requirements, the Philippine president, he's free to enter into any executive agreements as he or she deems fit. Now, another interesting thing about domestic decision is that the court has ruled that not just certain provisions of treaties are customary, but the entire treaty. In fact, there are court decisions where non-binding soft law instruments have been recognized as customary, such as the UDHR. And so this tells us that our Philippine court is quite liberal in identifying treaties and non-binding instruments as custom. Moving on to custom. Now, the Philippine court follows the definition of custom and the elements required for custom, but the court relies mainly on scholars and not on official documents. So that tells us that our court has a liberal acceptance of scholarly writings, or what Article 38 would call the teachings of the most highly qualified publicists. Also, as far as the applicability of custom is concerned, under Philippine law, custom becomes part of Philippine law, becomes part of the law of the land through our incorporation clause. But interestingly, there are decisions by the court which says that even without a constitution, the customs of international law applies in the Philippines. Again, a very liberal interpretation. As for the identification of custom, the court has identified many, perhaps in my opinion, too many customary norms. And in identifying these customs, the court does not analyze the evidence for opinion juris or state practice. And it's therefore very liberal. General principles of law have also been more recently recognized by the Philippine court as entering the Philippine jurisdiction also through the incorporation clause. The court has also identified several general principles of law, including estoppel, res judicata, equity, and so on. And the court has also recognized general principles of law coming from both the domestic legal system and the international legal system. Perhaps one interesting thing about the formal sources of law under Philippine court decision is that the Philippine court has recognized international jurisprudence as a formal source of law. As you know, it's not one of the formal sources under Article 38. So, under Philippine law, there are more sources, formal sources of international law than what you find in the ICJ statute. So, for general observations, we can see that the Philippine Supreme Court tends to be more liberal than international courts when considering what is a source of law. And for the Philippines, this liberality might be a good thing because that means international law can be applied more liberally in our jurisdiction. And this broader application may translate into more significant influence of international law in domestic affairs. And if this liberality is typical of domestic courts in Southeast Asia, then international law can significantly influence the region. So let me just almost conclude with some recommendations. First, the recording of state practice. I think there must be a mechanism where state practice will be recorded. Now, you have yearbooks of international law in Southeast Asia, but I think it might be a good idea to have a Southeast Asian yearbook of international law. And particular emphasis may be given to the recording of domestic court decisions because they can be evidence of many of the sources of law that we've discussed earlier. Second, and this is probably where we need other scholars, other than not just lawyers, because we need to take a look at Southeast Asian values. The diversity of the entire continent of Asia, it might be impossible to come up with some kind of list of Asian values, but Southeast Asian values might be more feasible. Academic institutions, experts groups, and non-governmental organizations may consider undertaking surveys and studies on Southeast Asian values. Thirdly, comparative law studies. Obviously, this will be helpful for determining general principles of law, as mentioned in the draft conclusions. And in fact, in the draft conclusions, an argument has been made for the possibility of a regional general principle of law. And this might have more buy-in from Southeast Asian states because it comes from their region and the rule does not come from the West. Finally, the role of writings. As you can see from the Philippine Supreme Court decisions, the court relies heavily on the writings of authors, most of them Western authors. And I think it's important that more scholars in Southeast Asia write from the point of view of Southeast Asia, so that this idea that international law is a Western imposition in the region will diminish or eventually cease to exist. So in conclusion, in the past, international law may have been a creation or a tool by the West as a means of dominating the rest of the world. It need not be the case in the future. The present offers opportunities for Southeast Asian states to influence the future design of international law. And with the dominating presence of China, perhaps it is even more important or imperative for Southeast Asia to develop its own voice and unify its stand. Otherwise, history might repeat itself and Southeast Asian states may find themselves subjugated again, though not by a Western master. Thank you.
Thank you. Thank you very much, Professor Cassis, for this very insightful and interesting presentation. I think that if our time allows, we will have a very interesting conversation on many of the points that you raised in your paper. But perhaps this can wait for a moment, because we have a speaker online who is waiting to connect and eager to share his comments and insights with us, Mr. Tikumporn Rodkhumwang, who will talk to us about rethinking the uniqueness of semi-coloniality in the international legal order, the Treaty of Bowring into the Kingdom of Siam. Tikumporn Rodkhumwang is a lecturer of international law at the School of Law of Mai Fa Luang University, Chiang Rai in Thailand. He has been teaching Introduction to Public International Law, International Human Rights Law, International Criminal Law, and Introduction to Legal Philosophy. He appears to be an extremely diverse and gifted lecturer because, just like many of us, he has to teach a lot and different courses. I have to say, I sympathize. So, his research interest lies in the history and theory of international law, in particular, the modern concept of global strategies. He holds master's degrees from Thailand and China, Chula Long faculty. Today he connects with us from Geneva in Switzerland. So Tikumporn, welcome to this conference. The floor is yours. I hope you can see us and hear us well.
Okay, am I audible, right? Can you hear me, right? Can you hear me, right?
Yes, yes, we can hear you perfectly. Please.
Okay, shall I share slide myself, or anyone there can share slide instead of me?
I think that we can share the slides with you. We can share your slides, so we have them available and we can show them. We just need a prompt from you in the words of change slide.
Okay, thank you very much. Okay, let's start with good morning, esteemed guests and presenters and viewers from online. And I am Tikumporn Rodkhumwang. I'm currently a doctoral student at the Faculty of Law and Department of International Law and International Organizations, University of Geneva. I just moved to Geneva like 2 months ago, and I'm interested in the history and theories of international law. That's the reason why I start writing this small research paper. And I would like to begin by expressing my gratitude to the conference organizers, especially Dr. Michael August, for scheduling this important event at the time when international legal study was beginning to decentralize. Hopefully it will be decentralized. I'm deeply grateful that you have included me in this momentous occasions, solicitation, and its re-engagement with international challenges and perspective is the title of the conference. In my opinion, the moment has come for us to get back into international legal education's full force for finding the unity within the diversity in international legal terms, especially by looking back into our history or historiography or historical interpretations for common understandings together. Subsequently, I turned in a big research papers called Rethinking the Uniqueness of Semi-Colonialities in International Legal Order that it has a subtitle as the functionality. I add some point that this will be a functionality of the treaties of Bowring into the Kingdom of Siam. It will be another perspective of perception, international legal perceptions of the colonialities. I try to prove another positive part of the unequal treaties in international legal studies will be my final resolutions of my research, small research project. And then I analyze how the Bowring Treaty affect the Kingdom of Siam. And after that, I turn it into the panel discussion. Thank you very much for including me too. First, I try to put this paper into a failures of for human security, colonialism, indigeneity, and extractivism in Southeast Asia. But now the panel is the source of public international and Southeast Asians. I try to work a lot, do further research since then. And this is the panel, which is where my research work will be present. My research focus is on how Siamese governments, Siamese elites, and were preparing themselves facing the Bowring treaties and the factual or administrative consequences from the Bowring treaties on that time. Next slide, please. And my presentations will consist of 5 sections, which I would like to outline before I begin. The first one will be the introductions of the rationale behind significance for the research process conferred, and secondly, the difficulty associated with global colonialism encouraged me with the title Empire and Globalization of Siam. I personally think the globalization process before the current globalization process, or it's come before neoliberalization or liberalizations. And the third point is international legal status of semi-colonialism. This is the first thing that I think when I do these small research projects, but now it's a little bit chipping into auto-coloniality. I will present further. And the Bowring Treaties and the global economic framework make up with the 4th part. And with that, I have completed my evaluations of Bowring Treaty making with Siam. It will be how can Siamese people localize Bowring Treaty into their practice. Okay, next slide, please. Now let's begin by to set the stage. The Kingdom of Thailand was formerly known as Siam in the history. International legal study paid little attention to this country, despite the fact that it has been the site of important discussion in international law, such as the Birmingham case before the International Court of Justice and the subsequent realization of the principle of estoppel in international law. And in these presentations, one of the main points will be changing process of making Siam and its changing landscape of the map. That's the reason why following these presentations is really like a huge 2 minutes of map that I will show what is the sequence and what is the conditions that make Siam become Thailand now. And after then, allow me to present you who is Sir John Bowring. He served final profession. He served as the governor of Hong Kong, and he was a translator, traveler, political economist. Importantly, he got the doctoral in laws from England before. When he was found in Siam, as long as he ascends to the positions of the very high position in Siamese monarchical system. His position is so-called Paya Siam Manukit Siamit Mahayot. This is a position that in the enormous bureaucratic system in Siam on that time in 1855. And King Rama IV named him envoy to London, while Queen Victoria appointed him as ambassador to Siam. Following this, on 1855, he concludes and he preparing his size pact with Siam. It's so-called treaties of friendship and commerce between Great Britain and Siam in April 1855 and ratified by April 5, 1856. That is the main focus, that it will be impact on the preparations process that on that time Siam faced at least two international treaty on that time. The first one is Bernie, that this will be another research, but this focus will be on only Bahrain treaties. And the treaty lasts for over 70 years until it's become fully ineffective in 1838. Okay, and it has a lot of consequence, for example, in administrative consequence. Next slide, please. Okay, according to Nicholas Caring, a minute. Sir John Baring, he is not only traveling into Siam on his purpose, but he seems to me like a very secrecy mission. On the Nicholas Caring studies, he said that this treaty making is a difficult and responsible business among such people. It is contrary to the traditions, notion, and habits of the masses to be in apparent surrendering rights to foreign power and especially Western power. It is contrary to the interests of the nobles to be openings for general competitions at trade, of which they now have the monopoly. If you look at the first part of the treaty, it will be the regulations that get the privilege to the British subject, and it regulate or dominates all the Siamese people into the proper positions when do the trade. Next slide, please. Slide 6. As we see a bit, the treaty welcomes Siam into the global economic culture. And on the signatory part of the treaties, it includes all the elites. Why the elites was very important on that time, because in the main text of the Bahrain Treaty is focused at least three things. The first thing is the fish, the second is the souls, the last one is the rights. That is very impact on Thai economic culture. From that time, the persons who get involved in this treaty is all of the elites. For example, in Thailand on that time, the claims of Bunnaks who always dominate the Chuga trade system in Thailand. And the Sir John Baring had to do some secrecy with these claims first, and then he tries to get all of the claims of the monarchical hierarchy or monarchical system or monarchical claims into this treaty, that it made Bahrain Treaty super effective on that time. Next slide, please. Okay, and there is a direct line as we interest in the history of international law. It will be a model, the same model of the Treaty of Nanking, and it was spreading all over Asia and Southeast Asia on that time. And the fact that the Bahrain Treaties took into account interests of the elites, including among the queens, is integrated. intend delve it further into this vital matter regard to encourage with regard the rice in particular. That I will discuss further why rice is very important until now. And the Barring Treaties was the first international treaties that make high rice export globally. Next slide, please. Slide 7. It will go over how Barring Treaty was adopted for use in Siam and how it was used to urbanize Bangkok. On that time, why it is very important, and from the British colonial side, they want the land, not only the harbor or the port. They also wanted the lands to establish, for example, the British embassy in Bangkok was located on that time. Next slide, please. Slide 8. Before Sir John Baring arrived in Siam, the country was allegedly getting ready for colonialism in all its neighborhoods. If we look at the map of Southeast Asia, all of our neighborhoods are colonized already. Why it's colonizations? They claim that it's because of their internal politics, because of their domestic legal system and the cultural assimilations. This is the work of Niti Il-Siwong on his work Pen and Cell, Literature and History in the early Bangkok. He explained a lot of process for preparing before entering into the Barring Treaties. And on this process, at the same time, it's not process for preparing Siam on Barring Treaty, but it's the preparing process of civilization of Siam, because of as we study international legal history, and it's Eurocentric, and they are dominate the civilizations. And this time before Barring Treaty, Siamese had preparations for the civilizations process. And next slide, please. Slide number 9. Before 1855, Siam has enormous area and gap on that time. If we look at the map, and these indicate that the government of Siam have become overly reliant on natural resources. It means that it's not only a big map, but it also includes a lot of natural and environmental resources, including river, canal. If we have time, we can look in the text of Barring Treaties. They was micromanaged all the canal in Bangkok. And on 18th or starting of 19th centuries, Bangkok is the locating of the most canals in Thailand. But since Barring Treaties entered into force, it's managed a lot of canals in Bangkok. And next slide, please. After Siam signed Barring Treaties in 1845, its territory was drastically reduced. As we have seen, we cut some parts of the northeast of Thailand to the French colonizers. We cut some parts of the northern parts into British Empire, something like that. Next slide, please. The factor that distinguished the Barring Conventions from other international legal systems, the initials and theory that treaties were unfair. The second reason was that Siam was receptive to international commerce culture. And this is theory that, and it is widely accepted from historians. If we don't have to sides with the Barring Treaties, we cannot get involved in international commerce culture or global economic culture. And the third one is the semi-colonialism culture was what it's for on that time. Next slide, please. Slide 12.
I hope you can hear me. So,
yes.
maybe because we have another speaker who is waiting to
Okay.
take the floor, could you
Okay.
please wrap up? Thank you very much.
Okay. Can I have at least like 2 minutes to do the conclusion?
Of course, thank you.
Okay. And my conclusion of this research, as I have said, that it will be a positive side of the unfair treaties. The first one, the Bali Treaty was unfair from a global or international legal perspective, but it encouraged Siam on that time to join international commercial system or global economic culture. As I have said, that the rice is the first, and until now is the first thing that it has a high value on the export in the global economic culture. In addition to training Siamese to be a global trader from the Bahrain treaties and inventing diplomatic channel further. We have never learned diplomatic studies before because of Bahrain treaties. This treaty teaches us a lot of diplomatics, how can we negotiate. And secondly, the regional view sees a hybrid of semi-colonialities and from the international politics perspective, it's not only a semi-coloniality, but it's also colonialities. We could see a sub-alternity everywhere in Southeast Asia with the following neighborhood. The last one, as I have said, that it changed a lot of local administrative in Bangkok and its surrounding area direct result from the Bali treaties. And the Bali Treaty is the first treaty or first international treaty that Thailand localized it into the local administrative authority. It shaped our models to be a local administrative organizations in Thailand. Okay, this is the end of my presentation. Thank you very much.
Thank you very much. And I think that with this very interesting presentation, it is now time to give the floor to Melissa Loya, who is online. Hello, Dr.
Yes, thank
Loya.
you.
Can you hear us? Everything?
Yes, I can hear you clearly.
Okay.
Are you able to hear me?
Yes. So, Dr. Melissa, a few words about Dr. Melissa Loya. Dr. Melissa Hib Loya is a postdoctoral fellow at the Center for European Comparative and Constitutional Legal Studies with the University of Copenhagen. She wrote the monograph, International Agreements Between Non-State Actors as a Source of International Law, published by Hart in 2022. Her research articles have been published in top international law journals, including the International Journal of Constitutional Law, the European Journal of International Law, the American Society of International Law Proceedings, the Leiden Journal of International Law, and International Law and Journal of the History of Ocean Development and International Law, and the Journal of the History of International Law. Dr. Loya earned her LLM with honors and her PhD with honors from the University of Hong Kong and completed her postdoctoral fellowship at the National University of Singapore, where she was awarded many prizes for her academic and scholarly achievements. Dr. Loya, thank you for joining us today. The floor is yours.
Thank you for the kind introduction. Good afternoon, everyone. The title of my paper and presentation is Riding the Capelletti Waves, the Philippine Supreme Court and the Sources of International Law. I shall be making 5 main points. The first main point is that the Philippine Supreme Court is engaging with primary and secondary rules of international law in various fields. The second main point is that its interpretation and application of primary rules of international law are inconsistent. The third main point is that its identification and application of secondary rules of norm separation and source ascertainment are arbitrary. the fourth main point is that, therefore, the trajectory of its engagement with international law is uncertain, and that the outcome of its engagement is instability and unpredictability of international law, masked as some form of temporal universalization, temporal or transactional universalization. Next slide, please. For my research framework, my starting point is actually the paper that I published in International Journal of Constitutional Law, where I make the following findings. First, that the four walls and dualist doctrines are withering away. And this is based on data that I presented in my paper, that Southeast Asian constitutional courts are engaging with international human rights norms. And in the same paper, I make the observation that its practice is arbitrary and inconsistent. And I cite numerous cases, including that from the Philippine Supreme Court with respect to the status of UDHR. But the trajectory of such inconsistent practice is to cast doubt on universalization. I was not able to explain this behavior of courts in Southeast Asia for lack of data and because the scope of the paper was very narrow. And so I looked into literature on how courts engage with norms in various fields, not just with respect to the primary rules, but also with respect to the secondary rules, and found a research gap in that there is no literature on that combination of questions. And so in this particular paper, I raised the following empirical and doctrinal questions. The first empirical question is whether the court engages with primary norms of international conventions, customary international law, and general principles of international law in different fields, not just human rights, and under different constitutional or political structures, whether colonial, authoritarian, liberal, democratic, or populist. And by primary rules, of course, I refer to the content, substance, or structure of norms spelled out as rights, obligations, responsibilities, and so on. The doctrinal question that I address in the paper is whether the court engages with secondary rules in the identification of norms by their source in convention, custom, or principle. And by secondary rules, of course, I refer to the formal and objective criteria for separating legal norms from non-legal norms, and by their source in the international legal order. And of course, the prevailing source can be identified in Article 38. So for my theoretical and conceptual tools, my reading of literature on judicial engagement with international law, I find a limitation in that the perspective applied is usually institutionalism. But then there are limitations to institutionalism pointed out in the very paper that I seek to expand on, and that is the notion of universalization is rather superficial, because underneath or in the area of source ascertainment, there is rupture among courts. And so I make use rather of the theoretical and conceptual tools of Capelletti and the theoretical and conceptual tools of Lustig and Weiler on third wave of constitutionalism. And now this particular direction in my inquiry is timely. Next slide, please. This is timely in the sense that there is a growing challenge against the claim to universality of Western liberal civilization standards as the foundation of international law, and also growing challenge against the authority of rules-based global regional governance regimes versus consent-based relations between sovereign states. And so the purpose of my paper and presentation is to foster a better understanding of the implications on international law of inconsistencies in international law engagement by courts. So next slide, please. My first research finding is, of course, empirical, and it is relating to the practice under American occupation when, under the 1902 and 1916 American laws, the Philippine Supreme Court had authority to engage in judicial review and in the process interpret and apply international law. And there I found numerous cases in which the court interpreted and applied the primary rules of the 1898 Treaty of Paris, of course, customary laws of war, customary international law on safe passage in times of war, customary international law on prisoners of war. And I found strict adherence to the criteria for source ascertainment. Now, the particular cases are discussed in the paper. I shall not discuss them here for lack of time. Now, during the post-war and post-colonial period, where there was a 1935 constitution, the confusion in the court until now regarding general accepted principles of international law as a part of the law of the nation and its in its equation to international custom as evidence of a general practice accepted as law that is the starting point there. And I could see numerous cases in which the court would fuse opinion juris with state practice. And it becomes symptomatic in its flip-flopping on the status of UDHR as soft law, customary international law, and general principles of law. In fact, in the most recent pronouncement on UDHR, it is categorized or characterized as all at once soft law, customary international law, and general principle of law, notwithstanding the structural contradictions involving those three categories. Now, there is also recognition of an American extraterritorial criminal jurisdiction based on customary international law on immunity. And therefore, here there was a bizarre transposition of a customary norm in a different regime and its use as basis for granting or recognition of extraterritorial criminal jurisdiction rather than relying on treaty law. And finally, there is recourse to authoritative writers as evidence of a particular source of international law. Now, during the martial law and liberal constitutional periods under the 1973 and 1987 Constitution, the most striking case in which the court seemed to deviate fundamentally from the sources of from the criteria for identifying sources of international law has to do with three Hague Conventions: the Apostille Convention, the Service Convention, and the Child Support Convention. All these conventions were implemented by the Supreme Court in the form of special rules of procedure. Yet these conventions did not undergo Senate concurrence, notwithstanding that these conventions conflict with existing laws and even preempt existing bills or legislative resolutions. And therefore, there's every possibility of the court having to resolve a conflict between a convention law or norm its own implementing law and a legislation, an existing legislation of the Philippine Congress. And finally, I discuss in the latter part of my paper a doctrinal finding regarding how the court addresses the category of use cogens norm. And this is the case of Cayetano, in which the court declared that though a use cogens norm is not supposed to be amended or repealed by a treaty provision, the codification of a particular norm in the Rome Statute diminishes the status of that norm and turns it into a mere treaty provision, and therefore no longer use cogens in nature. And this I found extremely troubling. The other case, of course, I discuss is the case involving the Spratly Islands as an offshore archipelago, and the seeming omission, or whether unwittingly or unwittingly by the Philippine Supreme Court, of a pivotal ruling in the South China Sea arbitration that the Philippines, China, Vietnam are not entitled to constitute any offshore archipelago in the South China Sea. And yet in this particular ruling, where one of the issues is the exact location of a petroleum service contract, whether it is situated within what is known in the Philippines as the Calayan Island Group as an offshore archipelago, or in the province of, or in the EEZ of the Philippines. And in that particular case, the Philippine Supreme Court reiterated the definition of the Spratly Islands as an offshore archipelago under a defunct presidential decree in 1978. And therefore, here there is a clear rupture from the South China Sea Arbitral Tribunal by the Supreme Court itself. And so, what are then the implications of my findings on this particular practice of the Philippine Supreme Court? And of course, the first one is that it degrades this particular practice of inconsistency and arbitrariness in source ascertainment and norm separation, degrades the normativity, predictability, and stability of international law. And in the process, it delegitimizes judicial engagement with international law itself. And all these two implications are the form of third wave constitutionalism that Lustig and Weiler warned will negate the gains of the first wave and second wave of constitutionalism. And therefore, based on my findings, the possible impact of the paper would be to cast light upon a peculiar form of third wave constitutionalism, and at the same time reveal that existing research on universalization of norms, values, and interpretation through judicial engagement with international law need to be re-examined. And so in conclusion, the inconsistencies in interpretation and application of international law by the Philippine Supreme Court are merely symptomatic of its arbitrariness in norm separation and source ascertainment. And they do cast doubt on the direction or the future or trajectory of national constitutionalism and transnational constitutionalism towards some form of universalization. Thank you very much.
Thank you very much, Dr. Loya, for this very interesting presentation. While we are waiting for Mr. Mirza, who we hope will be joining us shortly, I think that I could open the floor for a Q&A session. And perhaps I could have the privilege of asking the first question. And my first question, of course, without any doubt, is going to be shared by Professor Cassis and by Dr. Loya. And that question concerns, of course, the decisions issued by the Supreme Court of the Republic of the Philippines and their interaction with the sources of public international law. I wanted to ask you a very simple question. Do you believe that the Supreme Court of the Philippines is acting in violation of international law by making these inconsistent findings? Thank you very much. Anybody who would like to answer this question can go first. Maybe I can ask with Dr. Loya because she was the critical view, and maybe turn to Professor Cassis later. Is that okay? So yes, Dr. Loya, what do you think? Is the Supreme Court of the Philippines violating international law by its flip-flopping inconsistencies?
Sorry, is the question addressed to me?
Yes, please. And I think that Professor Cassis will pick up after you on the same question. But first, you, if you don't mind.
Is the question how the audio is not very well, is not very good? Could you please explain, could you please say clearly the question? Or
Yes, let me repeat the question a little bit more slowly. We have heard your presentation with a lot of interest, particularly the part where you explained that the Supreme Court of the Philippines is flip-flopping with the sources of international law in its jurisprudence. And my question to you is whether by doing so, the Supreme Court of the Philippines is violating international law.
Okay.
Thank you.
Thank you. So your question is whether, because of its inconsistencies, the Supreme Court is violating international law.
Yes, that is my question.
All right. Thank you very much. First of all, the interpretation and application of international law by the Philippine Supreme Court is intended to resolve domestic cases and is intended to have application domestically. And in its application and interpretation, it would justify its result, its outcome, as a compliance, a fulfillment of international law. And of course, as students of international law, we are aware that the acts of the Supreme Court can be considered an act also of the state. It can be attributed to the state. But here, the interpretation and application, in good faith, wittingly or unwittingly, is labeled or characterized as a compliance by the Supreme Court. It is only at the academic level that we can see inconsistencies over a period. In my case, in the case of my paper, it is an inconsistency that I trace over a period of 70 years, and without any effort on the part of the Supreme Court to rectify or to reconcile the inconsistencies. So as far as your question is concerned, number one, no, according to the Supreme Court, they are not violating international law. They're merely interpreting and applying international law to domestic issues. And number two, what for me as an academic would be the impact or implication of the practices of the Philippine Supreme Court is to negate the notion of a universalization, a progression towards universalization. So thus, Doreen, Lustig, and Weiler cited numerous cases in which courts, in their case studies, do deviate from what they consider to be the proper application of source identification or norm separation, but they do not consider the practices of the court as a violation or a breach of international law, but rather a deviation to signify a third wave, a sort of judicial review and engagement with international law that denies the idea of a universalization and therefore a natural progression towards a common notion of international law or homogenization of international law. Thank you.
Thank you very much, Dr. Loya. I will now give the floor to Professor Cassis to also share his remarks on the same question. Professor Cassis, please.
Thank you, Michael. Before, before I answer your question directly, let me first say that I am sympathetic to the views expressed by Melissa. Um, and I have written papers in the past of a similar tenor to what she was saying, calling what the Supreme Court has done as a divergence from what is actual international law. It's just that in this paper, which I'm presenting today, I have chosen to characterize such divergence not as errors on the part of the court, but as a form of reinterpretation of international law. But I do agree with the inconsistencies and the arbitrariness that Melissa has pointed out. In fact, the last paper I think I published is on that same case. She mentioned Pangilinan versus Cayetano, which was an exegesis, or better, I think a better title would have probably been an exorcism of that case. But anyway, going back to the question, do you believe that the Supreme Court is acting in violation of international law? Now, in typical academic or scholarly fashion, I will first question the question. What do you mean by international law? Because even from our Philippine perspective, our foremost academic in international law is the late Dean Merlin Magallona. And he coined the phrase, the concepts, objective international law and the Philippine practice of international law. So what we teach in international law, in our LLMs, that would be objective international law. Now, how the Supreme Court actually rules on international law, that would be the Philippine practice of international law. So if you by international law you mean the Philippine practice of international, and obviously, as Melissa is correct, it is certainly not wrong because it is the Supreme Court that determines what international law is from the Philippine perspective. But if you're looking at it from objective international law, obviously, yes, we are not compliant. For the example I gave earlier was the liberalization of what would constitute formal sources. And certainly it is in violation of Article 38 of the ICJ statute. So, as a Philippine representative in this conference, I would rather say that in the context of re-engaging international law from a developing country perspective, like the Philippines, it is the court's way of engaging international law by interpreting it in ways that are favorable to the state, whether or not such interpretation is consistent with what we might call mainstream understanding of international law is a different matter altogether. So, as you can see, I did not really answer the question.
Thank you very much, Professor Cassis. I think that your answer was very insightful, and I also want to thank Dr. Loya also for her very, very interesting answer. With everyone's permission, I would also like to ask a question from Tikumporn. Tikumporn, I hope you can hear me. And my question to you would be this. You talked about the Treaty of Bowring as an unequal treaty. And I would like to ask you if, in your view, this treaty is valid today, particularly to the extent that it influences the existence and maintenance of international borders between Thailand and its neighbors. Thank you.
Okay, thank you very much. Thank you very much for your questions. If I understand your questions correctly, what is the current effect of the Bowring Treaty if it's still effective, right?
Yes.
Okay. The first thing is from Thailand perspective only, it will be improve a lot of local administrative. For example, it will create a tons of taxing system because in the annex of the Bowring Treaties on that time, it categorize a very detailed of, for example, wood and sauce and fish and every single goods and service. I think if it's effective on today, it will be improve our custom first, and second, this will be improve our taxing system. Second, this will be improve our negotiation process. It will be improve our diplomatic way of trading system. The last one that I can think as quick as I can, it can destroy the hierarchical of the human being in Thai society. Yes, because it obviously affects from the Bowling treaties. In another factor is that it stopped the slavery system in Thailand. It's not real slavery, but it's like the same as the hierarchical between elites and labor in Thailand at that time. It destroyed all the slavery trading system. You can sell the people to be a worker on that house. You can buy the worker from that house to in this house, but it's completely destroyed this system in Thailand. This is the three quick things that I can think about if the Bowling Treaty is effective on this day. Thank you very much.
Thank you very much for your answer. Now I think it's time to have some questions from the audience for our distinguished speakers. So yes, please.
I have a follow-up question to the previous discussion about inconsistency, interpretation, and application of sources in the Supreme Court of the Philippines. Now, first of all, that's not unique. That problem, let's say, or phenomenon is not unique to the Philippine Supreme Court, and it's not a matter of developing countries. In the U.S. SCOTUS, in the UK, Supreme Court, they have more or less similar issues. The best illustration would be how judges understand the principle of treaty interpretation. Some judges focus on text, some other would be more, all of the elements in the Article 31 VCLC. So my point is that it's not unique. So perhaps it's good to use this phenomenon as a sort of reflection of a more general phenomenon in the world, actually. Now, one of the questions would be, how do we explain it, or what causes the inconsistent interpretation and application of sources? Is it a matter of the lack of expertise of public international law on the part of judges? Is it a matter of, in the proceedings we don't have expert witness, or there's no official positions from Minister of Foreign Affairs in the process, for example, that would allow different judges to interpret sources sort of differently, right? So in your views, how do we explain this, or the reasons behind this phenomenon? And perhaps this is why we see a sort of different interpretation between Professor Cassis and Dr. Loya, right? So for example, when Professor Cassis said, this is a matter of reinterpretation of sources, that seems to be, or seems to suggest that it was deliberate. It is deliberate on the part of judges. They want to reinterpret what is generally understood to be sources of international law, as understood by international lawyers commonly, and to reinterpret them to serve national interests, right? So how do we explain this inconsistency? Thank you, and divergence.
Thank you for your question. And obviously when panelists say thank you for your question, they're actually delaying because they're thinking of the answer to the question. Yeah, I agree with you. It's not unique. But of course my expertise is on Philippine experience, so I'm speaking from the Philippine experience, and I don't think it would be fair for me to speak on Thai experience for that matter. But I do agree with you. I imagine that this inconsistency is not unique. And I agree with you as well. I think the primary reason why there is a divergence, an error, a reinterpretation, whatever you may want to call it, is because of a lack of expertise. Of course, I'm not saying that Philippine Supreme Court justices are not experts. I will not say that. But if I were to imagine, that is probably the reason why there are errors in decisions. A failure to differentiate, I agree with Melissa on this, between general principles of law, for instance, and generally accepted principles of law. They sound very much the same. You find that in a law book somewhere, in international law, you copy-paste it and you put it in your decision, not realizing that they come from, they're two entirely different concepts. And that the reason for the lack of expertise is probably from a number of factors. Developing countries will always say, well, there's a lack of teaching material in international law in Southeast Asia. Some countries might say that, well, because international law, if you're a justice and you rose from the ranks from a city court position, you never really encountered international law issues until you reach that level. And it also goes into the manner of appointment of Supreme Court justices. Are they chosen because they are experts in particular fields or because they happen to be a political appointment? So there could be a number of reasons. And I think it's important that we understand that we may not necessarily, perhaps it might be a bit unreasonable to expect, of course, in a perfect world, you would want all your Supreme Court justices to be expert in various fields of law. But we don't live in a perfect world. So I suppose, and that's why the role of law clerks, for instance, working with justices would be very important. I've seen how decisions on international law have improved dramatically when the law clerk who happened to be working with the justice is one who is proficient in the field. But we cannot expect all the sitting justices to do that. There seems to be also, from the point of view of the Philippines, and I guess it's okay for me to say this because it's a public record, there seems to be a distinction between academic standards for judges and for academics. The example I gave is something that I am a part of. There was a time when a sitting Supreme Court justice was criticized for plagiarizing a decision. I was one of those lawyers who had to be defended before the court because they were threatening to remove our license because, how dare we mere academics criticize the Supreme Court justice for a plagiarized decision. And the final decision of the Supreme Court was, well, the standard for plagiarism for judicial decisions is different from the academy. So maybe that's another reason as well. The idea that judicial decisions are not necessarily academic writings, but are simply decisions that are required to resolve specific issues and should not be considered as treatises on the law. But again, there could be a number of factors. But again, thank you for your question.
Dr. Loya, maybe you would also like to share your views on this question?
Yes.
Thank you.
I understand the question because from the beginning of my paper, even the first paper in ICON, I struggled with the idea of how to explain these inconsistencies in the practices of the courts. And I immediately looked into the concept of institutionalism and the notions of judicial dialogue, judicial convergence, judicial politics, judicial socialization. And these are the ideas that have been used to explain the role of courts towards universalization of norms. And yet the practices that I describe in my papers completely contradicts the idea, the notion that there is universalization and that the trajectory is inevitable. Rather, what I see in my paper is a contradiction of that trajectory, a reversal. That is why it's called by Lustig and Weiler the third wave, which cancels out the first wave of national constitutionalism and the second wave of transnational constitutionalism. Rather, third wave perception or perspective starts from the idea that this reversal is very much in the structure of the courts. And because what they seek to universalize is a Western concept of liberal democracy. And what they seek to transpose into the domestic system is a notion or a normative concept that is not indigenous. And because of that, certain contradictions arise that force the court to reverse itself, reverse its course away from universalization and towards a peculiar form of application of international norms, which is not anymore based on sources of international law. Therefore, the rules, when we say interpret the sources of international law, that's rather a dangerous concept, because sources of international law, the rules are no longer supposed to be interpreted. They are the meta rules. They are the secondary rules for source ascertainment and norm separation. That they're supposed to be already the theory behind each norm. So what I see instead is a transactional use of the sources of international law to deal with certain cases to achieve a certain outcome, the best possible outcome for a liberal democratic project. And this is where certain contradictions arise, because the structure itself of the court does not permit an immediate transposition of these liberal concepts. And the most striking example that I find in my data is the automatic implementation of 3 Hague Conventions in complete disregard of existing laws that contradict those conventions, or that are in conflict with those conventions. And therefore here, almost the role of the court is to universalize a Hague norm, a Hague regime, in disregard, in complete disregard of existing legislation that are supposed or presumed to be the product of a democratic process. Thank you.
Thank you very much. Another question? Yes.
Good afternoon. I'm Judge Cynthia Martinez Florando from the Philippines. Now, in support of my employer, the Supreme Court of the Philippines, this study, as I understand, I'm not an expert in international law because I am lined with civil law. It's just that, as I understand, all the cases, the studied cases, were decided by the Supreme Court way back in 1970. Correct me if I'm wrong, Doc. It's just that the decisions, the discrepancies or the divergence in the decisions of the Supreme Court depends on the time when these decisions were penned or promulgated by the Supreme Court. You see, what is good in 1970s or in 1980s is not the same as of the present. What is the opposition in 1970s, 1980s, 1990s decisions may be now the majority decisions of the Supreme Court justices. If you look at our rules, there is what we call amendment to the rules based on the decisions. So the new provisions of our rules are based on the decisions already promulgated by the Supreme Court. And in fact, I just had my JSEP, my Judicial Regional Enhancement Program, where Attorney Palacios, the Dean of UPBGC, UPBGC lectured that we have to incorporate in our decisions international laws. But as a judge in the second level court, I have to conform with the decisions of the Supreme Court based on the principle of stare decisis. So we follow. But the decisions of the Supreme Court, if I may, are based on evidence brought to them. Not directly, but brought to the trial courts. We only base our decisions based on what is brought before us, and we cannot go beyond We cannot go beyond. Now, with regard to the testimonies of experts, of course, we do our own research. If this testimony, the opinions, because if expert witnesses can give their opinions, we base it also on our research. But with regard to the application of international laws, it depends on the circumstances or the issues to be resolved in a case-to-case basis. And as a second-level court judge, I can only apply these international principles if it's already incorporated by the Supreme Court in one of their decisions in a particular case. It's not a question, but it's just my opinion on what is lectured earlier. Thank you.
May I respond? Oh, if there's time.
Yes, yes, Melissa, please, you can respond first. Thank you.
Thank you. The purpose of the panel, I think, is to ascertain to what extent courts in Asia are able to contribute to the progression towards universalization of international law. And here, the findings, my paper, for instance, would indicate that the court need, first of all, to be aware that there are secondary rules for source ascertainment and norm separation, and that even if they do come up with decisions that seem to adopt certain norms of international law, certain primary rules of international law, that does not ensure universalization, principally because there will be instability in international law. There will be unpredictability in that one norm would be applied one day and another norm will have to be applied the next day, simply because there is no consensus on what are the norm, what are the rules for identification of these norms as part of international law. And therefore, if we come up with a paper that identify these problematic areas in the practices of the court, perhaps the courts can fix their own institutions, can improve their own systems so that they would be consistent with the secondary sources of, with the secondary rules of international law, and therefore contribute towards what would be desired as a universalization of certain norms. Thank you.
Thank you very much. From Professor Cass, a brief comment, please. Thank you.
Yes, thank you. I sympathize with the comment from the judge. I also teach at the Philippine Judicial Academy. I'm part of the International Law Department. And there is a difficulty at that level, municipal, regional, trial court level, to find an understanding of international law. Simply also because what we teach in the PhilJA is objective international law, but what you have in your legal precedents would be the Philippine practice of international law. And I understand the difficulty. But I think the standards of international law may change over time. Rules might develop over time, like the conventions that Melissa mentioned, we're now parties to that. But it's not a matter of the evidence. It's a matter of applying what the current rules are. And I think if the Supreme Court chooses to decide this way and not in accordance with what is the current international law standard, then it has the power to do so. I guess what we're trying to do is point simply out that it's not consistent. Now, is it wrong? Certainly not, because it's the Supreme Court that determines what is right and what is wrong. So I sympathize with you having to rule on the basis of the precedents and not on the basis of what might be taught in objective international law. So, thank you for your comment.
And thanks to the Dutch National Rail Service, we are very happy to welcome the panel. Mirza, thank you very much for joining us. We are going to interrupt our Q&A so that we can give you the floor briefly yet effectively to talk a little bit about your paper written together with Yogi Subandi and Sonan Savi on the Southeast Asian influence of public international law, states practice and implications. Please, the floor is yours.
Dear honorable guests, ladies and gentlemen, thank you very much for the opportunity which has been bestowed upon me. My deep apology for the train delay. There was this technical incident by which there was a strike, so it had to be moved back to 9 a.m. So my very deep apology. Okay, I would like to make it short. So as you can see from the title of our presentation, it's all about ASEAN and its state practice and how it has influenced international law in general. If we can move to the next slide. May I stand up? Oh yeah, sure. Okay, thank you. Okay, so Southeast Asia, with its sole regional organization known as Association of Southeast Asian Nations, or ASEAN, is one of the most rapidly and developed regional organization in the world. And during its existence for the last 50 years, since its inception in 1967, it has developed a lot, particularly in terms of how it has influenced international law practice in general, such as international treaties, as well as customary law. Now, what we need to understand is the fact that what is it exactly that ASEAN has in general, by which ASEAN has really contributed to the development of international law itself. And there are practices which I can show you here, that we have customary law, and we have Islamic law, colonial legacy law, of course, socialist law, the application of non-intervention principle, contributions to international maritime law in general as well. And these are the things which, of course, have contributed to the practice of international law all across the globe. So there are, of course, specific cases by which Southeast Asian legal norms have influenced international legal treaties, customary law, and general legal principles. For instance, like the concept of compliance on international law itself in the region. Of course, many ASEAN member states have adopted numerous of international legal treaties, both written and, let's say, unwritten in terms of customary international law. All of ASEAN member states, for instance, are party of the United Nations Convention of the Law of the Sea, and all of us are also party of the Kyoto Protocol. So many global affairs issues by which these issues have been very much of our concern for the last few years. All of ASEAN member states are actually in part of numerous legal instruments governing these daunting issues. Okay, in terms of legislative challenges, legal interpretation, of course, there are many international standards which, of course, require ratification from each of ASEAN member states through our parliamentary system. Some international legal instruments have been implemented 100%. Some of them are waiting for let's say, national parliamentary legislation, but these are processes which, of course, need patience because, again, this is all about state sovereignty. Again, in terms of non-intervention principle as part of ASEAN Way, as our ideology of how this principle is actually carried out, it is actually sensible when we say that many international treaties, you can name them, require, of course, national ratification in each and every ASEAN member states. And the same thing also applies to Indonesia, my home country. Of course, in terms of level of compliance, yes, there are, of course, issues by which how society in ASEAN in general are complied to, let's say, be obliged by the law which actually has been ratified and implemented in ASEAN in general as a regional organization. But of course, there are some people who, let's say, still require in terms of how their public awareness should be improved. And this is, of course, the homework, not just ASEAN society in general, but of course, each and every member state's national government in particular as to how they could infuse such law in such a way that every international legal instruments can be applied in such a way that every society from every societal elements can actually be obliged in, let's say, complying with all the things that have been ratified before.